For the first subtopic, it will be on the terms and conditions of a franchise agreement. The Franchise Act requires a franchise agreement to contain a minimum content, and this is under Section 18 sub 2 of the Franchise Act. It includes the name and description of the franchise, the territorial rights of franchisee, and the obligations of franchisor and franchisee, a statement on the cooling off period, and the description of trademark and any other IP rights to be used. So what happens if you don't fulfill this minimum content? Under Section 18 sub 3, your agreement will be rendered null and void. However, there is a new Franchise Amendment Act, which has just recently been gazetted, but it is not yet enforced. So the Amendment Act will delete this Section 18 sub 3. So if you don't fulfill the minimum content, your agreement will no longer be null and void. So that is the effect. And so regardless of whether Section 18 sub 3 is deleted or not, a person who does not include this minimum content commits an offense, and this is under Section 14 sub C in the Amendment Act. Now, the Franchise Act also requires the agreement to be drafted in a certain way. So while the Act does not say that these obligations must be in, but when you do the registration, they will ask you to specify where in your franchise agreement has this content. The first one is that the franchise agreement must be in writing. Number 2 is the cooling off period, which shall not be less than 7 days. So during this cooling off period, the franchisee has the option to terminate the franchise agreement, and the franchisor has to refund all money that has been paid back to the franchisee, except for an amount reasonable to cover the expenses incurred by the franchisor to prepare the agreement. The third key notable requirement is that a franchisor is required to register his trademark with our Malaysian MyIPO before they apply for the registration of franchise. And number 4, the franchise term must not be less than 5 years. So a franchise agreement cannot be for 4 years or 3 years. It must be 5 years or more. Number 5, a franchisee is required to provide a written guarantee to the franchisor that the franchisee, including his director, spouse, and immediate family, or his employees, he must guarantee that they will all not disclose to any person of the franchise trade secrets during the franchise term and for 2 years after the expiration or termination of the franchise agreement. The number 6 is franchisee must also provide a written guarantee that the franchisee and his affiliates shall not compete with the franchise business during the franchise term and for 2 years after the termination. So point 7 is that parties cannot agree to waive compliance with the Franchise Act, and if there is such terms in the franchise agreement, these terms will be void. Okay, if there is a breach by the franchisee, the franchisor must give a written notice and allow the franchisee to remedy, and this notice must be at least 14 days. Now, number 9, the franchisor is also obligated to provide assistance to a franchisee to operate the franchise business, and this includes like a provision or supply of materials and trainings. Okay, point number 10, a franchisor and franchisee cannot terminate the franchise agreement before expiration except for good cause. So examples of good cause can be found in the Franchise Act, and it includes failure to remedy a breach even after due notice is given. It also includes situations where no notice is required, and some examples will be bankruptcy or winding up or abandonment of the franchise business. So if any of this happens, it will be good cause, and you can terminate the franchise agreement prior to the expiration. I go to point 11 now. A franchisee may, at his option, apply for an extension by giving a written notice to the franchisor of not less than 6 months prior to the expiration. So a franchisee has like an option to extend the franchise agreement if he wants to. Point number 12, if such franchise agreement is extended, the conditions in the new franchise agreement cannot be less favorable than the conditions in the previous franchise agreement. So let's say if I want to extend the franchise agreement, you cannot force me to accept terms that are less favorable than what we already have.